assume Rich reset that up for me. Actually, I don't know if he did, to be honest. There it goes. You're now live.
Awesome. Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara. We're with the Ishihara and Parker law firm here in Longview, Texas. And today's topic's always a fun one for us, is basically what is it executor? What does it mean to be an executor?
Yeah, well, mostly because people really misunderstand that one. So 2 really important points on how you actually become an executor. First, someone has to name you as their choice in their will.
Yep.
Well, I guess 3 things maybe. And then that person has to pass away. And then what is most commonly misunderstood is that folks then start referring to themselves as the executor. That is wrong. You are not actually the executor until the court has opened to probate, admitted the will to probate as a valid will, and then accepted the decedent's request that you be appointed as the executor. So I guess that's 3. We'll call that 3. Yep. You have to be named in someone else's will. That person then has to pass away, and then you have to probate that will, meaning the court has to appoint you as the executor. And so, a lot of times we have kids or spouses that refer to themselves as the executor when you're really not, and it matters because if you aren't the executor, you don't have the authority to speak on behalf of the estate. So it is a really important distinction to understand.
And all that relates back to the biggest issue we see is folks bring in wills for their loved ones that passed away many, many years ago. And we ask, did you probate this will? And they say, yes. And I said, great. So you went to court, you were appointed as independent executor or executrix, as the will says, and they say, no, I was just named. Remember, the will process, the will must be probated. And as part of that process, the loved one that your person named would serve as the executor. They're named. It's not the oldest child. It's not the favorite daughter. It's a named position. It's in the will, which must be probated before the court to have legal effect.
Yeah, it's just so confusing. And we get it. But, sometimes they'll say, well, I don't need to probate this because I have a will. Yeah. Incorrect. Will plus probate, transitions title, and then appoints an executor and does all those things. But the existence of a will really has no legal meaning, which I know is like hard to, so why do I have to have one then? Well, because then Texas law writes one for you. So it's super duper important to have a will, but just expect that your will needs to be probated at your death. That's how people are going to handle things. That's how an executor is appointed. And that's, that's just how business gets handled at that point. Yeah. So it is really important to do a good job, and I know we've talked about this in other videos, but it's super important that your executor be appointed as an independent executor. That means the court doesn't have to oversee them, that they be appointed in that will to serve without bond, that they be appointed to sell without the court's permission. If those things aren't really clearly lined out in your will, what happens?
Oh, gosh. If that doesn't happen, then we have to go to court to figure out who's going to be in charge. We usually have to get waivers from all the heirs. We need the cooperation of sometimes far-flung family members who may not
like you.
Yeah. Them or the other heirs. I mean, it can get quite spicy on this. I've done it before where I'll have a loved one name one child to serve, and if they can't do it, it's the next child and the next child. I've had other families come in and say, oh, we want co-executors where Bob and Sally can serve. I don't really care what you choose
Bob
per
and Sally
se.
don't get along.
But right, you have to know your kid's personality. This is not a voyage of healing. If you pass away and you have kids who don't normally see eye to eye, forcing them to be in fiduciary positions to each other involved in the court and attorneys is a surefire way for it to backfire.
Spend a lot of money.
Yeah, exactly. And they each get their own lawyer. I mean, it's crazy. So pick someone who's in charge that's reliable, and then pick the next person,
Let's say, Chris, that I made a will 20 years ago, and so in there I put my spouse, and then I put my sister because she was the adult at the time. My kids weren't old enough, and I never updated it. So when I die, my spouse has predeceased me, and my sister is, either she's passed away also, or she's 90 and in a nursing home and can't serve. Then what happens then? Do I have an executor?
You do not have an executor. You have a problem. If your sister's passed away, then we'll have to apply to the court for an administrator to serve. We would need waivers from all the heirs involved. If sister's still alive but incapacitated, oh my goodness, we'll probably need proof of incapacity. Hopefully she's not so incapacitated she couldn't waive. I mean, you're adding multiple steps that are not efficient.
Right. So great that you have a will.
Yep.
But you've missed one of the important steps in keeping the independent executor up to date, because when you have to appoint an administrator, that person may or may not have the same freedoms that an independent executor named in your will is, because the court sees that as, well, this person didn't appoint an executor, so we don't know what the decedent's wishes are as to who they want to administer the estate, and so they look to your natural heirs at law to see who they would appoint. So now we got to go back to having all those natural heirs at law sign something saying they support you being appointed, they support you serving without bond, they support you selling the property of the estate with or without court oversight, which if you have 4 kids that get along great, God bless you, good job. But that's, that is a problem that all those people are going to have to sign things. So could it work out just fine for you? Absolutely. Could it be a giant headache? Absolutely. How often should we be reviewing those wills, Chris? If I have a will and it's 20 years old, how often do I need to be thinking about reviewing that will?
If your will's 20 years old, you need to come on in and we'll look it over, because it's probably wrong. Laws changed a bunch. Some of the language has changed. There's all sorts of estate tax changes. If 20 years old will, it needs to be reviewed. Yeah, I mean, I think usually your documents once a year. It's sort of like checking your smoke detector alarm batteries. It's just one of the things you need to go through. Like, hey, I named my son, but my son's going through a divorce. Maybe he's not a great person to serve as executor. Or I named my daughter, but heaven forbid she predeceased me. There's just things out there that need to be taken care of, and not having them will add time and expense.
Yep, and it doesn't mean you have to pay to go see the lawyer every year, but do think about, are my beneficiaries the same? Are my agents the same? And then, fortunately or unfortunately, the executor is one that has to be done with the same formalities that your will was put into place with. So it's not something usually you want to write out at home. It's something you do if you determine you need to add an executor or change that list. You do and should go see an attorney to do a codicil, an update to your will, maybe an amendment to the trust you have. But those are things you really want to do through the lawyer, as opposed to trying to do that on your own. There's some things it's fine to do on your own, personal property memos and those things, but this is a change that you really need to see the lawyer about.
So to be clear, what Kristen is saying is do not take your authenticated, your notarized, witnessed will and pull out a pen and start scratching things out and initialing and putting down new people's names. That doesn't work. Don't do that. It'll make the will look crazy, and it's not effective.
It's not valid. Yeah, that's right. You cannot just scratch through this person's name and add somebody else. That is not a valid change to a will.
All the time, and I'm like,
what does the court do in that scenario, Chris?
Yeah, so in that case, the court is going to ignore your change.
Correct. We ignore your scribbles, and we use the original will because that's the only one that's been validly executed. So if I've taken it and I've scribbled out my ex-husband, who I don't want to get anything, and his brother, who was my executor, the court is not going to make those changes for me. I needed to have taken the opportunity while alive to go see a lawyer and have it updated correctly.
Yeah. Think of this as ex-spouse Monday. If it's a Monday, let's go through and make sure that if you are divorced, you update all your beneficiaries, including your will and positions of authority. Don't leave them as your power of attorney. Let's update that stuff. I see a bunch of those come in. Second marriages, just on a side note, second marriages, and I see them naming the first spouse. Let's remember what we own, and let's update it to current facts. Your current family will be very appreciative of you getting it right.
Yeah, but what is an executor? So just a normal practical definition is an executor is someone who has been named in a will, who has then been appointed by the court after the decedent has passed away to handle the affairs of the estate. So the executor is the person that would sell a house, sell a car, collect life insurance if it is coming to the estate versus going to beneficiaries. They would have an immediate duty to safeguard the assets of that estate because as the executor, they have a fiduciary role. And they're, I don't want to say liable, but they are responsible to the beneficiaries as well as liable if they do something incorrect because they're serving in a role that you've appointed them in as a trusted person that will act in the best interest of your estate, which is there to benefit your beneficiaries, which may often be your kids, but whoever it may be. So what does that mean? That means if you are going to name an executor, you should probably talk to him about it first. Make sure they're willing to serve in that role. Make sure they don't mind to be appointed. What if, Chris, I've named my good friend and I die and she doesn't want to serve?
Yep, she can always resign. That's why when you did your executor list, you listed multiple executors. If not Sally, then John, not John, then Mary, not Mary, then Joe. You want to have, strength and depth of multiple reliable, good people to serve. And these people need to know where your original will is or have access to it.
Yep.
I've had many people show up and say, I'm the executor. How do you know that? Well, they told me. Do you have the will? Nope. Do you have a copy of the will? Nope. Right. So we need the person who's the executor needs to know how to and where the original will is.
What if I have nobody to serve in that role?
If you have nobody to serve in that role, we can always nominate third parties such as banks, accountants, CPAs. So there's always a solution. Of course, I tell everybody as a general rule, go out and let's make a bigger circle of friends. Let's join the Longview Mall walking group. Let's go watch birds. Let's join a church group. But yes, other than that, there are people who can step in that. Sometimes we just have unreliable agents. Got kids, we love them, but golly, not people we want to put in charge. That might be a situation. We look at a local bank or a CPA or someone like that.
Yep. Yeah, I would say the pros and cons are you're getting a professional, so we know it's removed from if there's any conflict within the family. This is a, insured and bonded type of corporate fiduciary. They're going to do the right thing. It may increase the time. It will definitely increase the cost, but that it'll be done correctly and, without conflict between family members. So there certainly is a time and place for that. And sometimes, you might think about person, corporate fiduciary. So sometimes you just put some things in line, and if those people aren't willing to serve or it's not a good time for them, you have already provided for that.
Yeah, if people are going to fight, it's always great to have them all mad at a local fiduciary versus one of the siblings.
Sure. It is a paid job, though, whether that is a corporate fiduciary or it is an individual. They are allowed to pay themselves. Typically in our wills, we call that reasonable compensation, but it is a job. They are doing a job for your estate, so it is appropriate to pay them, and it is something generally people should be expected to get paid for.
Yeah, let them decide not to if they don't want to, but the general rule is they get some sort of compensation, of course, Texas law. Yeah,
we have on our website as well as a printout that you can pick up at our office, but the duties of a Texas independent executor. If you are talking to somebody about serving in that role, that's a good thing to share with them. Do you want to go through a couple of these, Chris?
Yeah. I mean, of course, it all starts with they need the original will. Without original will, they're dead in the water. So let's have a place where they know where the original will is, and they're going to take it to go see an attorney. Just because you're named executor, just because there's a will, doesn't always mean that will must go through the formal probate process, but that's a decision for the attorney to make, not for the executor.
Yep. Upon appointment as the executor, typically the attorney that you hired to do this would help you through this, but you're going to file an oath. You're going to file a bond if that's necessary. Often that's been waived, but if you need that, a lot of courts have personal representative information that they collect. But after you've been to court, the judges said this is a valid will, and you're now the executor. What you ultimately end up with are called letters testamentary. So as you're calling around and notifying people of death, that's usually what they're asking you for. And it's a very strange term because people will say, well, they say I need a letter. Can you write me a letter? No. What you need is letters testamentary. It's only issued from the court after you've been appointed as the executor so that everybody knows you're the only person to talk to in charge of the estate. You can't delegate that. If you're the person named, you are the person named. You're the one that's got to call. You're the one that's got to sign. You're the one that's got to sell the car. You got to sell the house. Yep. You got to handle the personal property. So you're it.
Yep, you're it. It is a bit of work sometimes. Once you get appointed by the court, once you get your letters of testamentary, you'll get an EIN number. You'll open up an estate account, and then all those checks that were made out to the decedent's estate, can now be deposited into the estate account. You, of course, then would start getting a list of debts that need to be handled, and then and only once those debts are satisfied would you distribute assets.
Right. And some of that is going to be as easy or as hard as that individual that passed away has made it. Yeah. So if I have multiple financial institutions, multiple banks, and I've listed no beneficiaries on them, my executor is going to have to call, then go through their process. Some financial institutions require that you close an account but open another one with them in the name of the estate before you're able to pull it out. Typically, if you walk into a bank and what they have is a checking account, they'll just close the account and write a check to you made payable to the estate, which then goes into that new estate bank account. But there can be multiple levels of going through the process to make sure all those things get handled.
Yeah.
And there's no secret trick to make that go faster. That's just legwork that you are doing as the executor.
Bureaucracy takes a while, and the more banks, more institutions, more life insurance, more stuff out there, the more time they're going to spend on it.
Yep. Within 30 days, you need to publish notice to creditors in the paper. That's just a published notice. It doesn't notify anybody individually. If there are known creditors of the estate, you may need to send them certified mail notice if they have a lien on something like a house or a car. If they could be permissive notice creditors, which would be a credit card or medical debt. You can give them notice that the estate has been open so they have the opportunity to come file their claim. That's in an effort to handle the affairs of the estate within a timely manner. Typically, you kind of want to set the expectation that an estate's going to take 12 to 18 months to administer. Doesn't have to. Fortunately, here in East Texas, getting the will probated and getting appointed as the executor typically takes less than a month. But in other places around the state or other states, that can take as much as a year. Just depends on the court's volume.
That's just to get to court,
right?
The appointed executor.
Right. And keep in mind, depending upon the family situation, you may have beneficiaries that are calling and saying, when am I getting a check? I've spent this check. I am waiting on a distribution.
That's right.
So while, yes, it is just a job, there is an emotional element. And, yep, certainly people looking to you to send them a check. Within 120 days, we're going to file those things with any creditors that do have liens or notes on property. Within 90 days, you're going to file an inventory. Talk to me about the inventory a little bit.
Yeah. So on the inventory, we'll be listing their assets, whether it's both real property or personal property. We'll make a list. We'll list down the value, whether it's community property, whether it's separate property. Basically, it's showing everyone what the decedent owned at the time of death, because obviously that's going to be important to the creditors. Does the estate have any funds? Are their assets to be distributed? What is the executor supposed to be managed? All that is kind of shown in the inventory. It can be amended if needed, but basically you get an idea of where they lived, what they drove, what assets they own should go on that list.
And it's public record. So this is one of the things that sometimes cause people to go, oh, maybe I don't want to probate my will. Maybe I do want to use a trust or something else. The will also has to notify any beneficiaries. So if I'm appointed as the executor, I've got to send a copy of that file-marked will notifying a beneficiary that the will has been probated, they're entitled to something. And then the Texas Estate Code gives me a certain amount of time, which is exactly 18 months, where I can handle the estate. But at that point of reaching 18 months, a beneficiary can ask me for an accounting because I've officially taken too long in handling the affairs of the estate. Hopefully it's relatively simple, but even, handling personal property within a house takes a long time. Dealing with a house that may need repairs, you can imagine the types of things that come up that could add time to those kind of things. What else do we have? Distribute property. You do want to always talk to a CPA, especially if there are retirement accounts involved. There might be a required minimum distribution that still needs to be handled. If there are any financial accounts that are going to come over, sometimes you want to take those as you can. Hopefully you're listed as a beneficiary. But there is a distinction between assets that go directly to beneficiaries that's outside of the probate estate, that has nothing to do with the executor. You can't get answers on it. You can't help facilitate that. You may also be a beneficiary of a partial interest of that, but it has nothing to do with you serving as the executor, versus the estate assets that do come through the estate, which are typically going to be house, personal property, car, and then anything that has no beneficiary or a failure of beneficiary listed. If they are assets that have beneficiaries, they're going to go directly to those beneficiaries, and you won't have the ability to say, oh, well, I'd like to get this check and pick it up and send it to my sister. Nope. Sister's got to do that on her own. Nothing you can do to help.
Yep. Beneficiaries outside of you as the executor, so they made that even easier.
Yep. Anything else we want to say about being an executor?
Only else I could think of is if you look at it and realize that one of the beneficiaries is disabled or receiving government assistance, that might be something to let the lawyer know. There may be some extraordinary steps that could be taken that might be able to protect those assets from the government.
Yep. Good point. There are some modifications in Texas that you can make to wills if a person didn't think to do that at the time that they were creating the will. So excellent point. But anyway, to be an executor, you have to be named in someone's will. That person has to pass away, and then the court has to probate the will and appoint you as the executor. Otherwise, you are technically not acting as an executor. So just want to make sure you understand where the authority for the estate is. You don't have it until you've actually been appointed by the court as the executor. And then now you have some fiduciary obligations and reporting to the court, so you should go through all of that with a lawyer, which you would have really had to have probated the will anyway. So anyway, that's probably it for us today. Thanks for joining us.
Bye.